Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk today about non-compete agreements connected to the sale of a business. As many folks know, Florida is aggressively pro-non-compete. Florida courts routinely and aggressively enforce non-compete agreements via issuance of preliminary injunctions. I often hear people say things like, oh, non-competes don't hold up, or, oh, Florida's a right-to-work state, that non-compete is therefore unenforceable. These sorts of suggestions are sheer and utter nonsense, and in fact, they are very dangerous nonsense and very bad business and legal advice. Florida is aggressively pro-non-compete, and nowhere is that more evident than in the context of the sale of a business. So let's take a look first at the temporal scope of sale of a business non-compete agreements. In the employment context, non-compete agreements have a much shorter timeline. In the sale of a business context, the time frame is greatly expanded. It can last much, much longer. So, for instance, in the employee context, you have the following framework. Anything less than 6 months, presumptively reasonable. Anything more than 2 months, presumptively unreasonable. In contrast, in the sale of a business situation, anything up to 3 years is presumptively reasonable. Anything more than 7 years is presumptively unreasonable. And then in between, you have a vast gray area. So you can have an employee non-compete agreement considered unreasonable after a year or a year and a half. But in the sale of a business context, you can have a 5, 6, even 7 year non-compete agreement before the court will say, okay, as a matter of law, this is unreasonable and is going to be enforceable. So that's the first point and the first takeaway. You're looking at a much longer time frame in terms of the restricted period. That's the first thing. Second, let's take a look at geography. Geography is actually going to be fairly similar. If the business sold operated in certain states or certain regions, then it's going to cross over, and those states or those regions are going to function as the restricted geographic territory. So now that we've gotten time and geography out of the way, let's take a look at legitimate business interests. And this is really the second big takeaway. In the sale of a business context, there are a number of other or different legitimate business interests that can justify enforcement vis-a-vis employment, where it's fairly limited. In the employment context, you most often see the big three, really the big two: confidential information and customers. And every once in a while, you'll see extraordinary or specialized training. But it's really just the first two: confidential information and customers. In the sale of a business context, you see the big two, quite frequently. You see confidential information and you see customers. But there's another. In the sale of a business context, it's really the big three. The third one is goodwill. And goodwill is the absolute wild card. So I'm not going to belabor the point. Confidential information, that's pretty self-explanatory. The company was sold to us. We acquired it. We acquired the confidential information. It would be unfair to let them get back into business and use that confidential information that belongs to us now against us. That's pretty standard, pretty straightforward. Customers. We acquired their book of business. We acquired their customer list. We acquired those relationships. And it would be unfair to let them get back into the business and start competing for those customers when we're in the process of trying to form that relationship. Again, that is a completely logical and reasonable position with respect to a legitimate business interest, and it's one that will be upheld time and time again. But there's even more than that. There's also the issue of goodwill. So goodwill is sort of a catch-all for the intangible value of the business. for the business being held in high regard, for certain relationships, for brand recognition, for the intangible value of doing business in a certain community, in a certain market over time, and what's been built up there with respect to the community. Goodwill is vague, it's broad, it's wide-ranging, and it's hard to really get a handle on. And that's what makes it so powerful in terms of asserting it as a legitimate business interest. Because when you assert things like confidential information, customer relationships, there are specific grounds on which those sorts of assertions can be challenged. If you claim, well, it's all about confidential information that needs protected, I can blow that up. I can find out that, the information you're claiming is confidential. Okay, what information is confidential? Give me bullet, point specifics in terms of exactly what you're saying is confidential. And I'm going to run that into the ground. I'm going to find out everybody you've ever disclosed that to, whether or not you've used confidentiality and non-disclosure agreements, whether or not that information is available to other competitors in the marketplace, etc. So I can blow up that confidential information claim more often than not. Customers, again, in many instances, the claim of customer relationships is subject to attack because under Florida law, only substantial customer relationships are protectable. So it can't just be, we did a little business with them here and there. It's got to be something substantial. In some cases, have even said near exclusive. So there are a number of ways to blow up the claimed customer relationship as the legitimate business interest necessary to support enforcement. I can show they weren't substantial relationships. I can say the nature of the industry precludes there from being substantial relationships. I can say that you didn't have any relationship with these people because you acquired the business, you did a terrible job, and then you squandered those relationships. So again, it's subject to attack. It's a specific contention, confidential information, customer relationships, and that renders it more readily subject to attack. The problem with Goodwill is that it's quite the opposite. Goodwill is vague, sort of nebulous, broad-ranging. It could damage our goodwill. And courts buy that. Courts will often buy that. If you have a sale of a business non-compete agreement, and it's at 5 years and it's written for 7 or 8, and someone wants to challenge it. The seller, for instance, wants to get back into the same business and challenge it. The buyer can raise goodwill, and the buyer can say, look, we're still absorbing that company into us. We're still absorbing the goodwill, and to let them get back into the market at this point would be unfair and it would be unreasonable. And in fact, I'll go a step further. I have seen cases, I have seen instances in which there's the sale of a business, okay? You've got the seller, you've got a company, they sell out to the buyer. The buyer steps in, takes over, and 2 or 3 years go by, and the buyer is not doing very well. In fact, they did a terrible job absorbing the purchased company, those employees, those business methods, that knowledge, etc. They're doing an absolutely terrible job, and they're losing customers left and right. And after 2 or 3 years, the acquiring company says, you know what, we're not really making a whole lot of money with this particular division coming from the company we acquired. So we are going to put that division on hold for the time being. We're just going to kind of step away from that market. We're going to do all this other stuff that's related, but this particular line or this particular product or market segment, we're just going to put that on ice for the time being because it's not really making us a whole bunch of money. Well, in some instances, the seller tries to step in and say, hey, we sold the business, they acquired it, 2.5 years have gone by, and we have a 7-year or 6-year non-compete agreement, but the buyer isn't even doing business in that particular market space. So we should be allowed to get back in because there's no legitimate business interest that could possibly justify keeping us out because they technically stepped out of the market. Doesn't work that way. Doesn't work that way. Under Florida law, and in fact under the law of many jurisdictions, when a company acquires a business, it has an absolute right to freeze the buyer, or rather freeze the seller, out of the market for a reasonable period of time. And from my perspective, in that sort of hypothetical where the acquiring company does it for 2.5 years, says, you know, nuts to this, it's not working the way we thought it was, we're going to put this on ice, we're going to step out of this segment right here and just go back to the drawing board, that doesn't give the buyer a necessary right to get back in, because the seller has stepped out of that market space. You might think there's no legitimate business interest there, and maybe there's not from a sort of traditional technical framework, but the buyer has an absolute right to keep the seller out of that market space for a reasonable period of time, point blank, no matter what. And if it's only been 2.5 years, if it's only been 3 years, I think you'd be hard pressed to get a court to say, nope, it's unenforceable, you can go ahead and get back in. The court would probably say, nope, you got to stay out. They still have time to decide what they're going to do, decide if they want to get back in, etc. So that's the general landscape. You have a longer horizon. Your geographic scope is fairly similar, and it's built off where the company was doing business. You still have the big two legitimate business interests in terms of confidential information and customer relationships. But then you have goodwill, and it's a catch-all, and it is really, really powerful when it's asserted the right way. So where does this come up? Where do these sorts of considerations become relevant? Well, I can give you a couple examples, okay? You have someone who sold a business, signed a 10-year non-compete agreement. Believe me, I see 10-year, I see 12-year, I see 14-year. I mean, some of them get pretty ridiculous. That's a very, easy example right there. Someone sold a business, they signed a 10-year non-compete agreement, 6 or 7 years have run. That's an instance where you could possibly bring a declaratory judgment action, have the 10 years declared unreasonable, and have the court determine that a reasonable amount of time had already run. There may be other situations in which less time has run, but for whatever reason, say 6 years have run and the company has point blank gotten out of the business, or the company has gone bankrupt and simply exited the marketplace altogether. In that instance, similar deal. You could probably bring a deck action and get back in. Then there are even other questions where, say, the seller wants to get back into the general market but sell one product line that the acquiring company recently started selling. So you have things like that where these sorts of considerations would become pertinent. So again, Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question or concern related to a non-compete agreement, or in this instance to a non-compete agreement tied to the sale of a business, please feel free to give me a call. Thanks for watching. Have a good day.